Good morning, everybody. I think it's appropriate that I go last because I am a litigator, and usually kind of in the chain of command or chronology of these type of situations, the litigator becomes involved after all the things Russell has talked about and even Scott has talked about have already transpired. And kind of the question about time of the essence earlier, it sounded like the contract documents were already drafted and executed, and now you were dealing with a dispute. What's it mean, and what are the ramifications of it? I have many times been in a litigation scenario with these battles of the forms, and I'm going to just go to my last slide and tell you a real life situation. Actually, it's a case that's still pending. And so to kind of put some real parameters on some of these legal concepts we were talking about, I have a case where I actually represent the seller of goods in this case, and our price quotation basically says the terms and conditions set forth in this price quotation shall be applicable to and shall supersede any provision in the buyer's purchase order. My terms govern. My client gets a purchase order, and by the way, these documents tend to be thick and boilerplate and buried in small print, and nobody reads them. So the purchase order said, if this purchase order constitutes buyer's acceptance of an offer, such acceptance is expressly made conditional on seller's assent to the terms of this purchase order. So you have a situation where the seller says, my terms govern, the buyer says, my terms govern. Well, when the terms are totally different, which they usually are, who wins? The reason why it's been so important in my case is because there were two primary situations where the terms were different. The first was payment. My client's price quotation said payments, when they're not received, are delinquent, they're due within 30 days, interest at a rate of 15%, or 1.5% per month, or 18% per annum is due. You don't pay me in 30 days, it's due, and I'm charging an interest of 18%. Pretty good. 18% is not a bad return, especially in today's environment. Well, the purchase order said nothing about timing of payment, but it did have what Russell alluded to before, a pay when paid clause, actually a pay if paid clause that says, I'm not going to pay you until my customer pays me. So what happens with that? Actually, in my case, the customer of the buyer, who my client didn't even know existed, didn't pay the buyer of the goods for a reason that really had nothing to do with my seller. So that's why these type of battle of the forms become so important. There was actually another provision that was really important in these battle of the forms in my case. My client's purchase or price quotation basically had a provision that said you can bring suit to enforce this provision in any court of competent jurisdiction in the state of Ohio, kind of a broad base. And my client actually is in Lake County. We sued in Lake County. The purchase order said any dispute arising out of this transaction shall be brought exclusively in the courts of Washington County, which is Marietta, Ohio, about as far south in the state as you can get. We didn't want to go there. They actually, in the lawsuit I filed in Lake County, they tried to move that case to Marietta. And Marietta is beautiful, but it's also 3 hours each way, and that becomes expensive. So what does the case law say about this? When you have these two forms that seemingly are irreconcilable. Russell talked about how the UCC says be first, kind of a divergence from the common law, which was the last shot. Well, my client was the first provision, but you also have this purchase order that kind of does have that magic language that Russell alluded to, expressly made conditional on seller's assent to the terms of the purchase order. But the courts have held, and actually, I haven't highlighted this, but here's where the case kind of turned and said, in the beginning of the work by seller shall be deemed to constitute such assent. It was kind of a gotcha. It's like, okay, I'm only going to agree to this if you agree to my terms, not yours, and if you start the work, you've indicated your agreement to those terms. And the courts will enforce this magic language, but they want to make sure that the seller in this case is aware of it and agrees to it. So you can't just kind of do this gotcha like, okay, my terms are going to govern. If you start the work, you've agreed to it. The courts have held that there has to be, first of all, the purchase order or the second document has to say, I want to make it clear to you that I'm only going to go forward to this deal if you agree to these terms. And there has to be some express acknowledgement on that side, not just to start the work, that yes, I do agree to those terms. So yes, you can use the magic language. Yes, you can say, my terms govern, but you can't say gotcha by slipping in the beginning of the work is enough to do it. You really have to make it clear that I'm only going forward if my terms govern, and there has to be some indication on the other side that yes, I hear you and I agree to it. I want to flip back. As a litigator, one of my favorite sayings is an ounce of prevention is worth a pound of cure, because, again, I get involved at a time where the documents already exist. And since I do commercial and business litigation, almost all of my disputes involve contracts. And of those disputes, the vast majority of them, and I recognize I'm kind of doing Monday morning quarterbacking because it's easy to realize what the problem is after it exists as opposed to before. But the vast majority of the problems that I encounter from a litigation standpoint could be avoided if the parties took the time to deal with the issue in the documents. You know, I understand, again, that there's some Monday morning quarterback aspect, but if you really sit down and focus on the problem and think it through and deal with it in the documents, you might spend a little money up front, but I can tell you this with utmost certainty. If you litigate it, it's going to cost you many times more what you will pay to have to consult with a lawyer to actually make sure that your rights are protected up front in the document. I've listed here just some of the things that you might want to think about in your documents to kind of even the playing field. You know, my job as a litigator is to, when I'm representing a plaintiff, it's to make them as whole or as close to whole as possible. And a lot of times, because of the way the documents are written, that's impossible. Because, especially when, let's just say you have a purchase order, you have a sale of goods for $25,000 you haven't been paid. So you come to me and you say, oh, I want you to sue that SOB and collect my $25,000. Well, from the time you've hired me and you're incurring my time and expense of going after that $25,000, it's really going to be hard for you to be made whole, because even if I collect the $25,000 relatively quickly, you're going to pay for my time. So even if I do a brilliant job and do it quickly, you're still going to get less than $25,000. Here's some of the things from the plaintiff's side that you can include to at least increase your chances of being made whole. You can have interest on late payments. Now, one thing that a lot of people do and think it's enforceable, they'll never have any interest provision in their purchase orders and in actually the documents, but they'll send an invoice that says a rate of 1.5% will be charged per month on past due balances. If you don't have some documents that signify some agreement for the buyer to pay interest, the fact that you've slapped that on your invoice doesn't mean that it's enforceable. In fact, it's not, because they never agreed to it. So one of the things you might want to do, if you're a seller and you say, look, if they don't pay, I at least want to get some interest, which will increase my chances of being made whole and might absorb some of the legal expense I'm going to incur, is to put a provision for interest that if you're late, you're going to pay that whatever percent per month or per year. If it's in the document, it's enforceable. Now, Ohio has what's called a statutory prejudgment interest rule. So that problem is alleviated to some extent, and case law says that if you have a contract, you are entitled to prejudgment interest as a matter of law from the date the claim accrued until you get paid. It used to be that the Ohio prejudgment interest rate was a flat 10%, which again was a pretty good rate of return. So, you know, if it took you 2 years of litigation to get paid, well, at least you're earning 10% on that money, and that's going to help diffuse some of your legal fees. But I believe in 2002 that changed, where the 10% wasn't a flat fee. It's now tied to a short-term treasury rate. I think the Ohio Department of Taxation every October comes out with what the rate is, and I believe in 2014 it's 3%. So if you want to have some meaningful interest rate where there really is some stigma, some stick for late payments, put it in your document. Attorney fee provisions. Many of you might have heard what's called the American rule, and that is, in America, each side pays their own attorney's fees. I can't tell you how many times somebody comes to me and says, well, I just don't want my damages, I want them to pay my attorney's fees. And I'm saying, that's not the way it works. Now, there's some statutory exceptions for like employment discrimination and something like that, but generally in commercial business litigation, each side pays their own lawyer, unless you put an attorney fee provision in your document that says the prevailing party shall pay an attorney fee. Those are enforceable. Courts will look at them for reasonableness, but they're generally enforceable. So again, if you want to be made whole in that $25,000 example that I gave you, put an interest provision in and put an attorney fee provision in. So the chances are that you get your $25,000 and you're not taking big chunks of that out to cover the cost of going after it. Forum selection clauses. I gave you that example in my case where one said Washington County. Courts will generally enforce forum selection clauses as long as there's a reasonable basis for including them. So you want to have the home game. If I imagine most people here in Northeast Ohio, you want your disputes litigated in Northeast Ohio. You won't have to go somewhere else in the state or somewhere else in the country. And generally, courts will enforce those. Jury trial waivers. I can tell you that I've done a number of jury trials. They are longer, they are way more expensive, and especially in commercial disputes, oftentimes they're not the best mechanism for resolving disputes. So again, people have a constitutional right to a jury in this country. However, by contract, and you have to make it conspicuous and it has to be clear, but you can waive juries and have a judge decide the dispute. And actually, in Cuyahoga County, we have a commercial docket where you have a select few judges that are well schooled in commercial disputes. So a lot of times you get a better deal having a judge decide your dispute, one of these commercial judges, than a jury of your peers. Understand what that might look like. Mediation and arbitration clauses. I'm a big fan of alternative dispute resolution, especially since with all of the paper that Russell talked about and all of the, especially with e-discovery, and people are sending emails and texts and voicemails and a lot of times taking it out of the judicial system and putting it in mediation, which is kind of mediation is not binding. The nice thing about it is no one can enforce a result on you that you don't agree to. An arbitration, which is more a private adjudication. Again, you can't force somebody to mediate, you can't force someone to arbitrate, but if there's a mediation and arbitration provision in your documents, courts will enforce them. Again, from a seller's side, Again, you may want personal guarantees or security interests to protect the collectability of the debt. And Russell talked a little bit about disclaimer of warranties, limitation of damages, and limitation of remedies and exclusion of damages. Again, those are enforceable, especially in a commercial context where there is equal bargaining power, you have sophisticated entities. So you can, yeah, we talked about the power washing example, but in a general, more commercial context, if you say, I'm not going to be liable for lost profits, consequential damages, I'm not going to be liable for anything other than repair or replacement of the product I sell you, generally, those provisions are enforceable. So, again, I know it might be taking business away from me, but I urge people who are involved in the purchase and sale of goods to have your lawyers, which are hopefully us, look at the contracts and spend money on that ounce of prevention to avoid the pound of cure again.